I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and today we're once again reaching into the Legal Hotline mailbag for our question. And the question goes something like this. Buyer completes their inspection of seller's property and damages seller's property. Sale falls apart. Seller wants to recover the cost of the damages from buyer's earnest money before refunding the earnest money to buyer. Question number one, is buyer liable for those damages? Number two, is seller entitled to buyer's earnest money to recover for those damages? If you want to discuss that issue amongst yourselves or think a little bit more about it, push the pause button. The answer is yes, buyer is liable for the damages caused to seller's property by buyer's inspector. Form 35 makes this very clear. The language in Form 35 says that buyer first of all, will not damage seller's property, and if any damage is done, seller will restore the condition of seller's property. Language is unequivocal in Form 35. So buyer is, in fact, responsible for damages caused by buyer's inspector. So the second question is, can seller retain some or all of buyer's earnest money to cover the damages caused by buyer's inspector? And the answer to that question is probably no. Remember the purpose of the earnest money. It's seller's liquidated damages in the event buyer breaches the agreement. If buyer has a contingency and properly terminates the agreement based on the contingency, then the language of the agreement says buyer recovers the earnest money. If seller tries to keep the earnest money to pay for damages done by buyer's inspector, seller may be causing their own problem under the purchase and sale agreement by failing to return the earnest money to the buyer. And fast forward to the time when we have a dispute in the courtroom, seller will be able to show that buyer's inspector damaged the house and that seller should have a recovery for those damages, but seller is going to have a problem defending against buyer's claim that buyer's entitled to a return of the earnest money. And whoever wins or loses that dispute, that's a significant outcome because the loser is probably going to have to pay the prevailing parties attorney fees and costs. So sellers do not want to be put in the position of potentially losing the earnest money claim, even if they have a separate claim for recovery of damages done by the inspector. Now, as real estate brokers, are you licensed to counsel your clients with respect to this issue? Simple answer is no, you're not, because we are very clearly talking about the parties' legal rights and obligations arising out of the purchase and sale agreement. So when you have a seller in this position, seller says, look, the buyer or the buyer's inspector damaged my house, I want to keep their earnest money, what do you need to do? You need to immediately advise them in writing to seek the advice of legal counsel. You're not licensed to answer this question for them. The answer is they need to separately pursue buyer for recovery of those damages. Now, are they going to want to do that? Well, probably not, because the earnest money seems like a ready source of funds. So that's not the news the seller is going to want to get, but it's the accurate legal advice. Don't put yourselves in the position of having to give any legal advice to seller. You're not licensed to do it. And besides, some lawyer out there might disagree with me and think that I'm giving bad legal advice. You certainly don't want to be repeating my legal advice if some lawyer representing the seller says it's bad legal advice. If you want to talk about this topic or how you as a broker handle a situation like this when your client is pressing for legal counsel and you know you just can't give it, then send an email to me. I'm happy to engage in a discussion about this with you. Legal Hotline at warealtor.org. Thank you for being a Washington Realtors member.